Hello, this is Law and Terrorism, the podcast series. I'm your professor, Glenn Torres-Spelliscy. Thanks for joining me. Thanks for joining me for this week's edition of 5 Key Questions. The topic this week relates to the use of force for humanitarian reasons, under the doctrine of the responsibility to protect. This usually relates to foreign intervention in internal conflicts where one or both sides is responsible for committing atrocities against the other. So let's get started. The Geneva Conventions break conflicts down into two types: international and non-international conflicts. An international conflict is defined as a conflict between two state parties to the conventions. Remember that all states are signatories to the Geneva Conventions. A non-international conflict is anything else. It includes civil wars, internal uprisings, and conflicts with non-state actors that spill across borders. The U.S. Supreme Court, for example, explained that the conflict with Al-Qaeda is a non-international conflict, even though it occurs across the borders of multiple nations. Because it is not between two state parties to the Geneva Conventions, it is non-international. The UN Charter is largely silent about internal wars. It gives no prescriptions for behavior. So we must turn to customary international law to understand the role that states may play in the internal conflicts of other states. The basic international legal principle with respect to internal conflicts is one of non-participation. This principle is an accepted component of customary international law and serves to limit the type of support that outsiders can give to participants in an internal conflict. But what about the exception to the use of force that we learned of in the last lecture, consent? Well, generally speaking, the principle of consent allows a state to request military assistance from other states in dealing with criminal or destabilizing elements, including terrorist elements. However, there is an argument that when a rebellion reaches a certain status, controlling significant territory and establishing a government, that the legal principle of non-intervention should come into play. The general idea is that when an organized insurgency occurs on a large scale, involving a substantial number of people or control over significant areas of the country, then neither side should receive international support. In an historic move in 2005, at the United Nations World Summit, states unanimously adopted the principles of the responsibility to protect. There are 3 basic pillars of this responsibility to protect doctrine. First, it is the primary responsibility of a state to protect their own population from the 4 crimes of genocide, war crimes, ethnic cleansing, and crimes against humanity, as well as from their incitement. It is the international community's responsibility to assist a state to fulfill its obligations. And it is the international community's responsibility to take timely and decisive action in accordance with the Charter in cases where the state has manifestly failed to protect its population from one or more of the 4 crimes. So, as you can see, although primary responsibility for protecting civilians is vested in the state government, the international community is under a legal obligation to take action where a state has failed to protect its population, or where it is the state itself that poses a threat to the domestic population. Critics of the responsibility to protect doctrine argue that it has proven ineffective, as larger nations have been unwilling to mobilize support to take decisive actions against abusive governments, and perhaps even more problematically, that intervention could set a dangerous precedent by allowing powerful states to breach the sovereignty of the less powerful under the pretense of the responsibility to protect. Indeed, we saw this with the Russian invasion of Ukraine in the spring of 2022. As President Putin was preparing the invasion, he manufactured fake stories of genocide by the Ukrainian government to justify it. As a result, if we are to embrace a robust principle of the responsibility to protect that allows for humanitarian intervention, we need to create safeguards to ensure that states are not able to cloak otherwise illegitimate actions under the guise of humanitarian goals. International law should develop high standards about when it is appropriate and limits to its use. For example, possible limits may include requirements that there only be an extremely grave violation of human rights, genocide, or atrocities on a mass scale, and that there be concrete evidence of such violations. That there can be no other means other than military intervention of rectifying the situation. That intervention should be supported by those who would benefit, i.e. the population of the state or the state itself. That intervention should cause less harm to the target state than would occur in the absence of intervention. And finally, that the intervener should immediately withdraw when its objectives of humanitarian protection are achieved. Now, should it be left to the states to make unilateral determinations as to when intervention is appropriate, or should it be left to the UN Security Council? The concern is that if unilateral determinations are acceptable, it is more likely to be subject to abuse. On the other hand, when the Security Council fails to act, should we sit by? Given the Security Council's reaction, or lack thereof, to the Darfur crisis, for example, can we rely on the Security Council to act in the appropriate circumstances? Under international law, it is left to the sole discretion of the Security Council to determine if there is a threat to the peace, breach of the peace, or an act of aggression. The Council again determines that in its sole discretion, and the Charter requires it to maintain or restore international peace and security. So I think there's a pretty strong argument that, under the law, the Security Council could determine that crimes against humanity, ethnic cleansing, genocide, or war crimes are occurring in a civil war, and that they constitute a threat to the peace that would authorize it to take measures under Article 41 or 42. However, one of the key drawbacks to relying on the Security Council to take necessary action is its political nature. Indeed, we have seen the limitations of its political construction played out with respect to the ongoing conflict in Syria.
The Syrian authorities continue ruthless repression, which, if not stopped now, can drive the country into a full-fledged civil war. In light of the manifest failure of the Syrian authorities to protect their citizens, the international community needs to take urgent and effective measures to protect the Syrian people. The United Nations Secretary General has urged the international community to act as one and take action in a collective and decisive manner to protect the Syrian people against the violations of their human rights and fundamental freedoms. All acts of murder, torture, and other forms of violence must be stopped immediately.
Despite repeated calls for international intervention to protect the people of Syria from what has been determined are crimes against humanity and war crimes, the Security Council remains locked in a pattern of inaction because of the reticence of China and Russia to become involved. The question of whether unilateral intervention is permitted is still a matter of debate in the international community. Well, there are two types of nonviolent sanctions that we can consider: collective sanctions imposed by the UN and individual sanctions imposed by a single state or a group of states. Now, all member states of the United Nations are responsible for implementing the sanctions issued by the Security Council. The primary type of sanctions are economic. The use and development of these types of sanctions have undergone some pretty significant changes over the last decades in order to more effectively target terrorist groups. Economic sanctions can, generally speaking, be divided into two types: general trade embargoes and targeted sanctions. General trade embargoes, which ban exports to and restrict imports from target states, are designed to disrupt the flow of goods and services in the target's economy, thereby putting downward pressure on the nation's economic viability. These types of embargoes, though, generally impose economic hardship disproportionately on poor and middle-class populations by depriving them of essential goods and services for which they are not economically positioned to secure substitutes, unlike the elites. Because of the effects that such sanctions have on the general population and the humanitarian concerns that are raised as a result, the Security Councils increasingly use what are called targeted or smart sanctions. They're designed to reduce the broad humanitarian impact of general trade embargoes by targeting select individuals through asset freezes and travel bans, as well as state and non-state entities, and reducing their access to economic resources. By depriving the individual or entity of resources within their country of residence, and preventing individuals from moving to a country where a friendly government may not aggressively enforce the sanctions, targeted sanctions regimes put pressure directly on the bad actors, and attempt to bring about compliance in a way that is designed to minimally affect the population as a whole. Well, that does it for this week's introductory podcast. Let me know if you have any questions, and I will see you next week for a new installment of 5 Key Questions.